Here is a short and simple evidence hypothetical, one that's testing very common issues in stereotypical ways. As always, we begin by taking a look at the call of the question. It's obvious that we're dealing with evidence, and we've got 4 items of evidence. So before we even read the fact pattern, we can basically outline what this answer is going to look like. For each of these 4 items, we're going to talk about logical relevance first, then we're going to identify as many of the objections as come to mind, discuss each of them separately, then we will reach a conclusion that narrowly and specifically answers the call of the question. For example, look at the call of the question, the first call of the question. Was the question asked in paragraph 1 objectionable? Discuss. Our conclusion will answer that question directly. Now, let's go to the top of the fact pattern and have a look at what they're offering. In paragraph 1, we find out about the underlying lawsuit. Our plaintiff is Mary, the defendant is Truckco, and the subject matter of the lawsuit is wrongful death. We find out the details of the accident. We find out that the driver of the defendant's truck, Boyd, died a week after the accident. We know about the defense. Truckco is asserting that Boyd is an independent contractor and not an employee. You can almost anticipate, just by reading that phrase, independent contractor, that there's going to be an issue of insurance. And sure enough, there is. We find out about what happens in the jury trial. Next, we get the 4 items of evidence, and we see that this fact pattern is challenging us to deliver 4 quick, short answers. This isn't even really an essay question in the way that a contracts or a constitutional law question can be said to really require a thread of consistent thinking from the very beginning to the very end. Here, we've got 4 items of evidence, and for each of them, we're going to have to talk about logical relevance, raise the various objections that come to mind, and then reach a conclusion that answers the question. So, as we look at item number 1, we've got the plaintiff calling the defendant's president as a hostile witness, and we get a leading question that also appears to be a compound question. But beyond that, we see that it raises issues of hearsay and public policy. The second item of evidence is the predictable insurance question. We've got a public policy objection, but here it appears to be offered to show ownership and control as opposed to being offered to infer liability. Item number 3 is a double hearsay problem. First we deal with the report, and then next we deal with the statement that's contained within the report. So item number 3 will require a somewhat more elaborate structure than either of the earlier 2 items of evidence. We turn to the 4th item of evidence, and we see a complicated character issue. But it seems evident that in the context of this lawsuit, the character of the decedent really is a part of the plaintiff's case. So this appears to be fair game, and it's going to require some fairly careful analysis by us. Turn the page and take a look at the outline of issues that I present for this fact pattern. You'll see that I do precisely what I advise you to do. So you see, for each item of evidence, I assign a Roman numeral. I lead off with relevance for each one of these items. Then I go into the objections that apply, and I reach a conclusion that is responsive to the question presented. So let's go into each item of evidence in a little bit more depth now to see how a good answer to this question might play out. The first item of evidence is Tom's alleged admission and offer to pay funeral expenses. Plaintiff wants to challenge Truckco's president with statements he allegedly made during a telephone conversation with Mary the day after the crash. If true, the statements would be relevant because they would support a finding of liability against the defendant. As framed, the question is both leading and compound. Although leading questions against an adverse witness are permissible, plaintiff's counsel should ask separate questions about each idea he wants to inquire about. The first objection is hearsay. Tom's statements were made out of court and are being offered in court to prove the truth of the matters asserted. They're hearsay, and they will be excluded from evidence unless there is an applicable exception. Tom allegedly told Mary the accident was Boyd's fault. This is an admission by a party, and it is deemed non-hearsay by the federal rules. Other jurisdictions would admit the statement as an exception to the hearsay rule. The bigger objection is public policy. Tom also allegedly offered to pay for Hal's funeral expenses. This statement is inadmissible for public policy reasons. The judicial system favors non-adversarial dispute resolution, and parties will be less inclined to try to work out their differences if statements made during negotiations could be used against them later on in court. By the way, this exclusion is stronger in federal court than it is in many state courts. The conclusion is that in federal court, Tom's entire statement is inadmissible for public policy reasons. In some states, the admission might come in, but the offer to pay funeral expenses is going to be excluded throughout the country. Next, we turn to item number 2, Truckco's liability insurance on Boyd's truck. The plaintiff asked Tom if Truckco had a liability insurance policy on the truck driven by Boyd at the time of the accident. The question is relevant because it attacks Truckco's assertion that Boyd was an independent contractor. It is not relevant on the liability issue. The objection is public policy. Evidence of insurance coverage usually is excluded as a matter of public policy. This is because juries may tend to impose liability on an insured party rather than focusing on the merits of the case. This evidence is also excluded to encourage parties to carry insurance. In this case, Truckco has defended Mary's action by claiming that Boyd was an independent contractor rather than a regular employee. If Truckco is liable for the truck, Boyd probably was an employee. So the conclusion is that despite the public policy against allowing evidence of insurance coverage, this question is permissible so long as it is asked to show Truckco's ownership and control over the truck. Next, we turn to the third item of evidence, which is Reno's testimony about Boyd's statement. It's relevant because it establishes liability. The plaintiff wants Officer Reno to read Boyd's admission of liability off of his report. This is relevant because it establishes liability. The objection is double hearsay. Officer Reno's report was written out of court, and it's being offered to prove the truth of the matter asserted. It is hearsay. Boyd's statement in the report also is hearsay. Both have to be excluded, unless an exception or an exclusion is present for each one. Let's begin with Reno's report. Officer Reno wrote this report in the regular course and scope of his employment. The report qualifies as a business record, which is an exception to hearsay. Furthermore, the report might qualify as a past recollection recorded, another exception to hearsay. Next, we examine Boyd's statement. Boyd told the officer that he fell asleep at the wheel and crossed the center line into oncoming traffic. This statement is an admission, which is non-hearsay under the federal rules, and it's an exception in other jurisdictions, as I mentioned earlier. Boyd is dead. That makes him unavailable, so the statement also qualifies as a declaration against interest, and it's deemed sufficiently reliable to qualify as an exception to hearsay. The conclusion is that Reno's testimony about Boyd's statement likely will be admitted. Finally, we turn to the fourth item of evidence, the objection to Smith's testimony. I'm going to conclude that the objection was improperly sustained. Let's examine relevance. Smith would have testified that Hal had a reputation for being quarrelsome and physically violent with Mary. Mary has sued Truckco for Hal's wrongful death. Smith's testimony would reduce the value of her loss of consortium claim. The objection, that I conclude was wrongly sustained, must have dealt with improper character evidence. Presumably, the court sustained plaintiff's objection on the ground that Smith's testimony was inadmissible character evidence. The problem with this is that Smith's testimony is not being offered to prove Hal acted in accord with his allegedly bad character. Mary testified that Hal loved her and was a kind and considerate spouse. The credibility of any witness may be challenged by the other party. Smith's testimony is a legitimate way to attack Mary's statement. So, my conclusion is that Smith's statement should have been admitted. Hal's treatment of Mary is at issue in this case. Smith's testimony would be of interest to a finder of fact, and there was no legitimate reason to exclude it. And that wraps up a consideration of a very straightforward, and therefore fairly demanding, evidence hypothetical.